Hi, and welcome to the Queenstown Law Virtual Cafe. Let's sit around and think about what happens if we die, said no one ever. But death and taxes can't be avoided, so it's best to think about what you want to happen to your assets upon death. You might not have millions of dollars in assets, but not having a plan is going to leave your family stressed at a time when they're already suffering. The sooner you have it sorted, the sooner you can relax knowing it's in order, so you can get on with ticking off the things in your bucket list. Let's look at a few of the questions that we commonly get asked. Number one, what if I die without a will? Then what happens to your assets will be decided not by you, but by the law. The first thing to consider is how big is your estate. If it's less than $15,000, then it can be distributed by your family. If it's more than $15,000, then someone needs to apply to the High Court to get permission to administer the estate. How is it going to be distributed? If you die without a will, then the law sets out who gets what depending on what surviving relatives you have. For example, if you've got a surviving spouse but no parents or children, then the spouse gets it all. If you've got a surviving spouse and children, then your personal effects go to the spouse, as well as assets to a value of $155,000, and then 1/3 of whatever is left goes to the spouse, with the children getting the remaining 2/3. What if there's a spouse, some surviving parents, but no children? Then once again, the spouse gets the personal effects, assets to a value of $155,000, and 2/3 of whatever is left, with the deceased's parents getting 1/3. The list goes on and on, describing all of the alternative family structures that might occur. So if you want to make the decisions on who gets what, you need a will. Let's look at the second question. I have a will, but I'm getting married. Will that will be okay after marriage? There's two answers to that question. If the will clearly states that it was made in contemplation of marriage, then the answer is yes, it will be valid. If it doesn't say that, then the answer is no, the will no longer be valid after the date of marriage. A final question. What happens to my home if my husband dies? We own it jointly. In that situation, the property will be transferred into your sole name by what is called survivorship. It will not fall for distribution under the terms of your will. Hopefully that's answered some of your questions. If you have any other questions or you'd like us to review your existing will to see if it does what you want it to do, give us a call on 03 450 0000 or drop me a line, scott@queenstownlaw.co.nz. We'll see you soon.